Hello, I'm David DeLugas, the $99 lawyer. This week I'm going to answer the question, do I want a jury trial? Now, if you're representing yourself, this is a question you're going to have to answer, and I'm going to try to help you figure out whether you do or you don't want a jury trial. If you're represented by an attorney, I will also help you decide whether you want to encourage your attorney to have a jury trial or to have the trial in front of a judge and let the judge alone make the factual determinations in your case. So here we go. First, let me explain what a jury trial entails. One thing that you would not have to do if you had your trial in front of the judge alone would be to prepare a consolidated pretrial order. This will require you to work with the other side, either the other party who's not represented by an attorney or by the attorney for the other side. And the consolidated pretrial order will include what your claims or contentions are, a list of all the witnesses you know you're going to call, and a list of the witnesses that you might call. It will also require you to list in advance all of the documents, photographs, and other exhibits that you might try to use during your trial, and you will have to identify any of the legal issues that you believe might come up during your case. You will also need to report whether there are any deposition transcripts that might be used instead of a live witness, and you will have to identify exactly what the law is under which you're making your claim or what your defenses are, and whether there are any remaining issues before you go to trial. Frankly, it's a rather labor-intensive process, as well as it is something that will disclose all of the information from your opponent as well as the information from you. Now, that can be a good thing because it is a tool that is used to narrow the issues for trial and see what is it exactly will take place in front of a jury. Well, then, after the judge accepts the consolidated pretrial and it's entered as an order of the court, you're no longer going to be allowed to amend your pleadings, either the answer or the original complaint. And again, it depends on which side of the claim you're on. Now, when you get called for trial, here's what will happen there. First, you're going to have to select a jury. But in truth, you don't pick the jurors on the jury that's going to hear your case. What will happen is, depending on your jurisdiction, you will start with a panel, that's what it's called, of perhaps 24 or 30 jurors, and you will go through and do what's called voir dire, a fancy term for you get to ask the jury panel members questions about themselves. They will identify their name, what part of the county in which they live, whether they're married, their occupation, and then other information you can ask them about that might be relevant to whether they may have some bias or prejudice toward any of the parties in the case, whether they know any of the witnesses, whether they have any particular religious belief or other belief that would prevent them from fairly, honestly considering the evidence that's produced and coming up with a factual verdict that represents a combination of the facts as they determine the facts to be and the law that is given to them by the judge. Does it sound complicated already? Well, part of why I picked this question is I just finished a 3-day jury trial, and as a veteran trial attorney, it remains a very intense experience, even for me, even with all of that experience. So, after you have this opportunity to question the jury and put in front of the jury your theme of your case, and this is a clever use of voir dire. Part of your questions trying to determine if there's any bias or prejudice will be to introduce what your case is about and what the theme is for your case. And through that, you're already starting to work the jury. By the way, the attorney for your opponent will be doing the same thing. Now, then, after going through this questioning period, you will let the clerk know in private which juror you don't want, and the other side will as well. And guess what? The juror that you've figured out is going to be such a great help to your case is going to be the juror the opponent identifies as somebody that would help your case if on the jury, so they are going to be stricken. And you will do the same thing. You will figure out which jurors are likely to be favorable to your opponent, and you will strike them. Now, whoever's left are going to be the jurors. So again, you don't select jurors, you strike jurors and take them off of the panel, and you're left with your 12 jurors. Well, then the judge will tell the plaintiff, are you ready? And the plaintiff will say yes, and you'll say, depending on whether you're the plaintiff or the defendant, are you ready? And once both sides are ready, the plaintiff gets up and offers what's called an opening statement. It's not evidence, but it is an outline of what the plaintiff expects the evidence will show from the witness stand, from people testifying under oath, and from documents, photographs, and other exhibits that are entered and accepted by the judge as being entered into evidence, and what that evidence is going to show. And perhaps a preview of, at the end of the case, the judge is going to instruct you as to the law, and the law in this area is going to say this or that, and together with the evidence we produce, we would like you to enter a verdict in favor of my client, or in your case, if you're representing yourself, in favor of me, for whatever that might be, whether it's I should win and not have to pay any money, or I should win and get paid by the other side, or I should win and get custody of my children, whatever that might be. Now, sound complicated yet? After the opening statements, each side begins their evidence. Now the plaintiff goes first, and the plaintiff calls witnesses, and the plaintiff can call you, if you're the defendant, for cross-examination alone. Whenever the plaintiff is done presenting the case, the plaintiff will say, the plaintiff rests, meaning there's no more evidence that the plaintiff intends to introduce. Now at this point, if the plaintiff has not introduced sufficient evidence to make out the case and meet all the elements of the claim, a directed verdict can be entered by the judge and take this case and kick it out. But if you're the defendant, you have to move and say, Your Honor, I move for a directed verdict. The judge will excuse the jury and hear arguments, as the legal arguments, as to why the plaintiff has not met their burden of proof in presenting the evidence necessary to sustain or meet their claims. Unlikely to get granted in most cases. Likely the plaintiff is going to introduce an adequate amount of evidence, unless you're the plaintiff and you fail to produce some piece of evidence, proper evidence, to support each element of your claim. Now, that means you need to know what the elements of your claim are. All right, so once that's done, the defendant gets to put on their evidence. And that goes, again, through witnesses under oath, documents, photographs, other tangible items that are accepted by the judge after they are identified by a witness under oath to be what they purport to be. This is a letter dated June 25th, 2012 from my opponent to me. And that's how you would identify a document, for example. And then you would say, Your Honor, I move to have admitted exhibit number 5. And then the judge will check with the other side as to whether there is any objection, legal objection. And if there is none, the judge will likely admit it. And if there is a legal objection, the judge will then ask you, well, what's your response? How do you respond to that legal objection? Now, I'm not trying to talk you out of a jury trial. I just want you to have a realistic understanding of what it entails, because it is very tempting to say, I don't want this judge. I don't like this judge doesn't like me. I'm going to have a jury decide this. Well, that's all fine and good, but you're going to have to learn how to do it. And it can be done. I don't know if there's a book for dummies on how to have a jury trial, and I hope you're familiar with that series of books that teach you to do just about anything from chess to scuba diving, but I'm not sure there is one for how to present your case to a jury, although I'm trying to give you a few tips right here. Or maybe not tips, I'm trying to give you a heads up on what you can expect. So after all the evidence is presented by the defendant would rest. And again, the plaintiff can, for example, ask for a directed verdict saying, based on the defendant's evidence, we should win and the jury shouldn't even get a chance to consider this case. Now, if the judge says overall, no, we're going to let the jury hear this, then you will have what's called a jury instruction or jury charge conference with the judge. Each side is supposed to have submitted in advance proposed jury instructions based upon either the pattern jury instructions in your jurisdiction and or the law that applies to your case. And those need to be written out in advance and submitted to the court. And the judge's law clerk will likely have gone through them and decided which ones she or he is suggesting to the judge be given to the jury. Then once the judge decides on what those charges are and listens to objections to charges that are being given that one party contends should not be given, or charges that each party believes should be given that the judge has decided not to give. The judge will bring the jury back in because they won't be there during this time of the jury charge conference, and the judge will instruct the jury as to the law. Now understand, the jury doesn't get to make up the law. The jury is going to be instructed that they have to follow the law as the judge is giving it to them. But the jury gets to decide what the facts are based upon the evidence, which presumably is conflicting because there's a plaintiff and a defendant who have a different version of the facts. So the jury is to decide the factual dispute, what the facts are, apply the facts to the law that the judge gives, and come up with a verdict. And the verdict is then turned into a judgment by the judge. And that is then filed with the clerk, and the case is over, ready to be appealed or ready to be followed by both parties because you've had your day in court. Now, based upon what I just described, a one-day jury trial, very difficult. It's not going to be easy to get all that done in one day, and it often takes 2, 3, or more days, and some jury trials last quite a while, as you probably know from the news. So the question you always have to ask yourself as you approach the judicial system with a case, a claim, either a lawsuit against you in which you decide, I'm going to have a jury decide this, no jury will find in favor of my opponent, or if you're the plaintiff seeking an outcome, relief, or a claim that you believe you should win, and you want a jury, yes, a jury might see the facts as you see them, but so might the judge. So study the judge, ask around, figure out if the judge is going to be fair, unbiased, and truly a judicial officer who listens carefully to the facts, or is going to be influenced by the attorney that has been hired by your opponent, or just doesn't like you for some reason. But again, if you're going to have a jury trial, you need to figure out how you're going to operate as effectively as the other side, either the other opponent, or your opponent's attorney. And unless you're very, very sharp, and unless you're going to put a lot of time and energy and effort into this, I'd tell you be very careful about going to a jury. Again, it sounds wonderful to have a jury of your peers, and the jury pool, the panel is going to be drawn from your county or area, and they may or may not be just like you. They may be, it might be, and should be, a rather diverse group of people. But I will say this about the jury that just concluded the trial I had, and juries I've had before. It's amazing. You take 12 strangers, put them together over a number of days, have them listen to evidence together, and believe it or not, collectively, they come up with a pretty fair outcome, although they're very unpredictable too. And they will fight and argue and stick to it, and the dynamics are amazing. But I add, and again, or say again, be very cautious about asking for a jury. It's a lot of work. And even if you have a trial before a judge, make sure you're ready and prepared. And if I can help in any way get you ready for your trial, if you've decided you cannot afford an attorney, or you have an attorney and you want somebody giving you a second view and thought about what's happening in your case, consider booking a session with me, the $99 lawyer. Thanks so very much.